Hey everybody, how's it going? Welcome back to Copper Jacket TV. So it looks like we could have a huge Second Amendment win incoming here thanks to the GOA. You know, the Bruen decision changed the Second Amendment landscape in this country forever. It also told the lower courts that, hey, look, you can't use the two-step approach anymore. The interest balancing approach is out the window when it comes to these types of cases. You know, in the past, the lower courts like the Ninth Circuit and the Third Circuit and the Fourth Circuit all used to say, hey, look, if public safety is a very important aspect of why the government is banning something or restricting your rights, then we're going to go ahead and side with the government over your rights. It was a huge problem. That's what the Ninth Circuit used all the time to uphold all of these gun control laws in the state of California, and other courts were doing the same thing. So obviously they can't do that anymore. The Bruen decision also said that we have a right to carry outside of the home for our own defense, and there are still states out there who are even ignoring that. Well, this GOA lawsuit is going to change everything. As a matter of fact, I believe it's going to have an effect on the entire country. So let's talk about what's going on. Now, real quick before we get started, if you're like me and you believe firmly in defending yourself and your loved ones, whether you're in the home or outside the home, you need to do what I did and sign up for attorneys on retainer. I mean, let's face it, not all self-defense incidents are clear-cut. If there is even a small question about whether or not what you did is right, there's a good chance that you're going to end up in handcuffs and you're going to be taken to jail. And you're going to need somebody that's going to be there for you to defend you. And that doesn't come from some pencil pusher in an insurance company. You need attorneys on retainer. If an incident pops up, you call attorneys on retainer. An attorney giving you instant client privilege will pick up the phone. They will guide you through things. They will be there to represent you, and they will take care of you all the way through court. Now, if you're interested in attorneys on retainer, go ahead and check out the link down in the description box. There is also a discount code, which is CJTV. That'll save you $50 off sign up. Okay, so let's go ahead and talk about what's going on here. So I don't think I've heard anybody talk about this case, even though it is a huge case that has national implications. Now, I did make a video recently talking about a case that was just filed in California by the FPC. This case is filed in the Northern District Court of New York, and this is looking to do the same thing as the FPC case. The case is Higbee v. James. Higbee is actually a news anchor for Newsmax. He's a Second Amendment advocate, and he wants to be able to carry when he goes into the state of New York. But just like California, New York does not have reciprocity with any other state and does not allow non-resident permits. So in New York, you have to be a resident of the state to get a permit. If you're not, forget about it. Now, oddly enough, New York, being, not the biggest state in the country, has 6% of this country's population, which means that 94% of the population of the United States loses their Second Amendment rights simply by crossing into New York's border. Because again, like I said in the beginning, Bruen says we have a right to carry outside of the home for our defense. It doesn't say that that right ends once you hit a certain state's border or a certain state doesn't like a particular amendment to our Constitution. It says that we have a right to carry. So leaning heavily on the Bruen decision, the GOA has decided to challenge that. And one thing I should mention is not only does New York not allow non-residents to carry, even if they have a permit from their own state or their own state is constitutional, but they make it almost impossible for their own residents to carry. So there's lawsuits challenging the sensitive locations aspect of recent laws and Bruen response bills in the state of New York. And now we have this bill challenging New York's ban on non-resident carry. Now, the reason that I think this is so important is because this could end up leading to national reciprocity. If we have these courts say that, hey, look, you can't simply ban somebody from carrying or ban the recognition of their permit because they're in a different state, or at least not have an avenue for them to get a permit in your state, well, that could end up going up to the Supreme Court. We could end up seeing national reciprocity just through one of these cases, maybe the FPC case or the GOA case. But either way, I believe that this is the path forward to national reciprocity. Let me just read you real quick some excerpts from the case itself. Okay, so let me go ahead and read you guys the complaint for declaratory and injunctive relief. So it says, 1 here, this case involves a challenge to New York's wholesale refusal to allow those who are not state residents to exercise their right to public carry while in the state of New York. In the NYSRPA v. Bruen, the Supreme Court unambiguously held that the Second Amendment guarantees a right to bear arms in public for self-defense. In the DC v. Heller case, the court explained that this right is exercised individually and belongs to all Americans. Number 3, in direct contravention of those clear holdings, New York provides no avenue for all Americans who are not residents of New York to bear arms in public. First, New York does not recognize or grant reciprocity to any concealed carry permits issued by any other state. Whereas someone from Massachusetts can drive into New York based on Massachusetts driver's license, the same Massachusetts citizen cannot carry a firearm into New York based on a Massachusetts concealed carry license. Second, New York does not allow New York residents who don't own a property in New York even to apply for a New York firearm permit, instead allowing only New York residents and some individuals who satisfy various exceptions, not relevant here, to apply. Third, because New York does not permit a person even to possess most firearms without a permit, the inability of non-residents to obtain a New York permit means they cannot even keep arms, even within a private domicile or private property. And because New York does not permit the open carry of firearms, there is no way for non-residents to bear arms in public without a permit or reciprocity. Thus, for the 94% of Americans who are non-residents of New York, the right to keep and bear arms in public simply does not exist within the state. No other provision of the Bill of Rights works this way. Now, just like the FPC case out of the state of California, I don't see how there's any way for a district court judge in the state of New York to possibly spin the Bruen decision in a direction that would let them think that it would be okay to simply block somebody's constitutional rights because they cross state lines. I don't see how that's possible. Now, I'm sure that they'll come up with some way where they'll work things around or change the wording, or they're maybe misinterpret a phrase that we used in Heller or Bruen to try and support the state's argument that they have a right to somehow block people from doing that. But regardless, there is no way, if you look at the text of Bruen, you take a look at Heller, and you see what the fundamental right that's being protected here is, there's no way that we don't end up getting a win in this case. Now, obviously, it might not happen at the district level. Maybe it goes up to the appellate level, and maybe the appellate court even finds a way to spin it. But in the end, there is no way that either of these cases from either of these states don't end up getting a win at some point, even if that win has to come from the Supreme Court. And if it comes from the Supreme Court, which is something that's going to have a national effect, just like Bruen did, you're going to see national reciprocity. That's the way that I view this. Now, I know these things take a long time. It's nice that we have competing lawsuits that have a good chance of winning. Each one has a fantastic chance of winning. Each one was written so eloquently and so perfect, with a perfect understanding of what Bruen and Heller meant and what the Second Amendment means and text, history, and tradition. Each one was written so well that I don't think there is any way that we don't get a win from one of these, regardless of where they end up. Now, I understand that in certain states, you might be thinking, if you're somebody who lives in New York or California, you're thinking, hey, fix my stuff here. I get that. There's lawsuits right now that are currently trying to fix carry in your states. But just like they said, a driver's license is recognized, which isn't even a right. Having a driver's license is a privilege, but for some reason they recognize that privilege, but not a right. And this is a very big deal. This is something to consider here, because if that's allowed to stand, what's to say that New York couldn't block your First Amendment right once you get to their state? Maybe you have free speech in 48 other states, but when you get to New York, free speech no longer exists because you're not a resident of New York. This is a very slippery slope that we have to pay attention to. So again, I'm glad that these lawsuits have been brought up. They're all moving forward. And again, I think this is going to lead us to national reciprocity. So I wanted to share that with you. I want to thank you all very much for watching. I really do appreciate it. Please like, subscribe. You guys have a great day.